Now we are back, and we'll start principle of non-interference. Rule in Foss versus Habertle. What has been said in this rule? This rule means minority will not interfere in case if majority is doing act according to the MOA and AOA of the company. So basically this is the principle in this rule of Foss versus Harbottle case, which was discussed. Now now we'll read it once. The rule provides that when majority does anything in exercise of power of internal administration, court will not usually intervene. In this case, at the instance of the shareholder in the matters of internal administration by director, so long they act within the powers conferred on them under the articles. Articles means what? Articles of the company. That means AOA they are asking about. Now here is a question that articles of the companies are the protective shield for the majority of shareholders. Comment. Here in this case, what articles they are talking about? They are talking about the articles of association of the company. If majority is doing in the internal affairs of the company within the articles, then minority then court will not interfere with the company's internal matters. Here, basic principle of non-interference with matter of administration of company was laid down by the court in celebrated case of Foss versus Harbottle. It provides no action can be brought by the member against director in respect of wrong alleged to be commented to the company. The company, that is majority itself, properly party of such an action. Majority is basically the party of that action. Here we discuss about the case. That case has been filed between Foss versus Harbottle. What has been held in this case? Two shareholders, Foss and Turton, brought an action on behalf of themselves and other shareholders against the directors and solicitors of the company. They basically filed a case against the directors and solicitors of the company. What allegations they are making? They have said that it was alleged that by their concerned and legal transactions, they had caused the company's property to be lost to the company. It was also alleged that there was no qualified board. They said that there is no qualified board, and whatever be the company's property, that is to be lost to the company. Damaged claim. They were asking about the damage. Plaintiff claimed damage to be paid by the defendant to the company. Okay. Now, what verdict has been in this case? Verdict was, it was held by the court that the action could not be brought by the minority. Minority means नहीं लेकर आ सकता है वो केस. ठीक है. They said this thing. The company that is majority is the proper plaintiff. मतलब what they said कि majority इस केस में proper plaintiff है, minority is not the proper plaintiff here for wrong done by the company. So majority of members are competent to decide whether to commence proceeding against the director. Basically what they want to say कि भाई majority है वो अपना loss तो करना नहीं चाहती है. Majority अगर कोई एक्शन ले रही है, that means वो अपने फाइनेंशियल्स और अपनी सारी चीज़ों को ध्यान में रखते हुए ले रही है, और मेजॉरिटी कभी कोई इसमें अपना नुकसान तो करेगी नहीं. तो इन केस मेजॉरिटी हियर इज़ द पार्टी टू फाइल द केस, नॉट द माइनॉरिटी. अगर मेजॉरिटी के साथ से सही हो रहा है, दैट मीन्स माइनॉरिटी के साथ भी सही हो रहा है. अगर दे आर गेटिंग प्रॉपर डिविडेंड एंड प्रॉपर बेनिफिट एंड प्रॉफिट ऑफ द कंपनी, द माइनॉरिटी ऑल्सो डूइंग द सेम, नो, ऑल्सो गेटिंग द सेम बेसिकली. So, same was held by Supreme Court in Rajamundry Electric Supply Company versus Nageshwara. Let it be, अगर ना भी याद रहे ये केस, बट सुप्रीम कोर्ट भी ने भी ये डिसाइड किया था. कोर्ट ने डिसाइड किया, देन सुप्रीम कोर्ट हैज़ ऑल्सो डिसाइडेड द सेम इन अनदर केस. नाउ from the above it follows that a company being a separate legal person, company is a separate legal person. Basically we know the member who compose it, the company is a proper person to bring action. Company action legi, not any other person, any minority shareholder have a right to file a suit. Then justification and advantage of rule in Foss versus Hardible. What are the justification of this case? The justification of this rule is that will the majority shall prevail, is that will of the majority shall prevail. Majority की मर्जी चलेगी यहाँ पे. They wants to say this thing. On becoming member of a company, a shareholder agrees to submit to the will of the majority. Therefore, rule encourages the right of the majority to decide how company affairs shall be conducted, which have been discussed to earlier. Majority doesn't want to lose their profit now. What are the main advantage of this rule? These things are really important. What are the advantage? We have to very precisely discussion about this topic. Now, recognition of separate legal personality of company. Here, what court has decided? What are the major advantage? That company has a separate legal person. That has been decided. Need to preserve right of the majority to decide. Majority have a right to decide because majority has invested their money in the company. So majority have a right to decide. Third thing, multiplicity of futile suits avoided. Futile we know which is not a fruitful. Means litigations, unnecessarily litigations has to be avoided. If minority shareholders are more than 20,000, more than a lakh shareholders and a lakh shareholders file suit against the company in a different courts, then it can be a multiplicity of the suits, na? So for this this case has been introduced that multiplicity of the futile suits avoided. फालतू के cases नहीं होंगे. That means litigation at suits on the minority of a minority futile if majority doesn't wish it. Litigation at suits of a minority के केस की कोई वो नहीं रहेगी इम्पोर्टेंस अगर प्रेफरेंस नहीं रहेगी, अगर मेजॉरिटी उससे चाहती नहीं है. तो अगर मेजॉरिटी ने what are the elaboration we'll check out in this is, but as far as about this line we concern that कि भाई मेजॉरिटी ने अगर कुछ बोल दिया है, मतलब माइनॉरिटी ने अगर सपोज कोई केस फाइल किया है एंड मेजॉरिटी डजंट वांट टू एग्री विद द केस, देन अगर मेजॉरिटी उससे एग्री करता है देन माइनॉरिटी हैव अ राइट टू प्रोसीड. इफ मेजॉरिटी उससे एग्री नहीं करता है देन देयर इज़ नो पॉइंट. सेकेंड, एप्लीकेशन ऑफ फॉस वर्सेस हार्बर्टल in the Indian context. In case of ICC versus Parsanpuria Synthetic Limited, Delhi High Court ने क्या held किया था? There are 3 different cases has been held. Delhi High Court ने कुछ और held किया है, then Kolkata High Court ने कुछ और held किया है, then other different cases has been. Okay, चलो ठीक है. Delhi High Court का will discuss. Delhi High Court ने ICICI versus Parshuram Synthetic Limited में held किया था. Indian corporate sector does not involve a large number of small shareholders. बहुत ज़्यादा नंबर नहीं कहते. Where it is predominantly funded by financial institutions. Financial institutions were considered as minority. Though they hold only small percentage of shares, it is the financial institution which have provided finance for the company existence. Hence, automatic application of phosphorus or Harbertl would be improper. Means that would not be proper. We'll discuss it. We'll come back to this case. I'll refer to another notes. But let it be. We'll come to the next topic. That is exception of Foss versus Harbertl case. Here, Foss versus Harbertl case में there are 7 exceptions. How many exceptions are there? 7. Now, the rule of supremacy of majority is subject to certain exceptions. कुछ exception है इस case में, otherwise majority is supreme. But there are 7 exceptions. After this, in every case, majority has a supremacy. Okay. Now with this ultra virus act, अगर majority ने कोई case ultra virus किया है, then minority have a right to file the case. Fraud on minority के साथ something fraud happen हुआ है, then they have a right to file. Wrongdoers are in control. Means management and wrongdoers, the person who have a right, who have a control over the affairs of the company, they are wrongdoers. So if they have a control over the company, then minority can file a suit in a court. Okay, then resolution requiring special majority but passed by a simple majority, which is very simple. If they breach the law, na, basically we can also say that they breach the law. Then Personal actions. Individual membership rights cannot be invaded by majority of shareholders. He is entitled of all the rights and privileges appearing to his status as a member. An individual shareholder is entitled to enforce his individual rights against the company. Means a single member can also file a suit against the company. It is an exception. We'll discuss it later on, that what can be done in this case if a single member comes into the picture. Then, breach of duty. Minority shareholders may bring an action against the company whether, although they are not no fraud, there is a breach of duty of directors and majority of shareholders in detriment of the company. Then, prevention of operation and mismanagement. Shareholders are empowered, minority shareholders are empowered to bring an action with a view of to prevent the majority from operation and mismanagement. These are statutory rights of minority. Here it's a very important section, that is section 241 to section 246. We have to discuss these sections in a very detailed manner. Here what we basically want to say that there must be operation, and operation what we call is abuse of authority in a continuity. It should not be a one time activity, it should be a recurring activity. Basically they want to say this thing. We'll discuss it on later on when we come to the operation. What operation does mean, what is the mismanagement does it mean. So what we have learned in this exceptions, that is ultra virus nahi hona chahiye, fraud and minority nahi hona chahiye, wrongdoers are in control nahi hona chahiye. If they breach of law like simple majority se tha and they a special majority thi, they did it for the simple majority, then it is void. Personal actions, when a single member is eligible, then breach of duty, and then prevention of mismanagement. Okay, we'll see and we'll discuss in another case. Thank you.